Hello, this is Elsa W. Smith, your Maryland startup business attorney. When starting a new business, you'll need to decide what business structure works best for you. The most common entities are the sole proprietorship, partnership, LLC, and corporation. You'll then need to decide how you want that business to be taxed. Here's where we start talking about S-corporations and C-Corps. The purpose of this video is to touch on some of the differences between S-Corps and C-Corps. Before we begin, I want to reiterate that when we talk about S-Corps and C-Corps, we are referring to how a business entity is taxed. S-Corp and C-Corp do not appear in a business's name, so you'll never see Jane's Bakery, S-Corp, or John's Bike Shop, C-Corp. A corporation is the most complex of the for-profit business organizations. In that sense, a new company that is growing into operational efficiency may find it more feasible to start with a partnership or LLC and see whether future success justifies transformation to a corporate structure. Importantly, certain tax choices must be made when the business formation process begins. By the way, the new Tax Cuts and Jobs Act is something you want to become familiar with and discuss with your startup business attorney. Subscribe to this channel to see my video discussing how the Act impacts you and what business structure may be right for you. You may have heard that the corporate legal structure suffers from double taxation. In the less complex business structures, such as the partnership and the LLC, the partners or members pay taxes only once, and this occurs on their personal income tax return. The income from the business is passed through to the individual's personal return without that income first being taxed by the IRS at the business level. With the sole proprietorship, the partnership, and the LLC, each of these entities is not taxed on income coming into the business and then to the individual on his or her personal return. Instead, the income of the business is subject to one tax only. By contrast, the C corporation or C Corp is taxed by its earnings at the corporate level. The profits then get distributed to the shareholders, usually in the form of dividends, which are reportable on the shareholder's personal income tax return, thus making the same funds twice liable for income taxes on the corporate and then on the personal individual level. The IRS assigns the newly filed corporate entity a C Corp tax status by default. For companies with 100 or fewer shareholders that have no intentions of going public, electing S-Corp status is available pursuant to Subchapter S of the Internal Revenue Code. An S-Corp is not subjected to double taxation. Instead, each shareholder reports corporate income on his or her personal income tax return, but the S-Corp does not pay income tax at the business level. Other conditions apply for S-Corp status eligibility. For example, the S-Corp cannot have a non-resident alien as a shareholder. It cannot issue more than one class of stock and is limited in the amount of capital that it can raise. If qualified, the S-Corp may operate with fewer formalities than the C-Corp. The C-Corp does have certain advantages over the S-Corp. It can accept foreign investors legally and is thus a stronger investment vehicle. It is not limited in the number of shareholders, the classes of stock issued, or the amount of capital invested. It is the model that must be used when transforming to a public offering. For more information to help your startup business process, subscribe to this channel. Click the subscribe button below this video. Is there a topic you'd like me to discuss or explain? Let me know in the comments section below. Follow me on social media at Elsa W. Smith Law on Facebook, Instagram, LinkedIn, and Twitter. I'm Elsa W. Smith, your Maryland startup business attorney. Thanks for listening. I'll see you next time.